Over the last decade, our cell phones have become completely intertwined with our lives. Our phones contain incredible amounts of personal data, such as our communications with others, our calendars, our internet searches, and our files. Given that so much private information is contained on our phones, it's natural to ask, can the police search my cell phone? The very short answer to that question is yes, the police can search your phone, but they will need to obtain a search warrant from a judge in order to do so, unless you consent to the search. I'm going to broadly discuss the circumstances when the police can search your phone. I'm going to break my discussion into two parts. First, when the police can physically search your phone for data. And second, when the police or the prosecution can get data about your cell phone from a third-party service provider, like your cell phone company. Before I discuss when the police are legally allowed to physically search through your phone, I want to provide the important caveat that if you consent, the police can legally search your phone even if they don't have probable cause or a warrant. Because of that, the police oftentimes will ask a suspect, "You have nothing to hide, right? Can I search through your phone?" Sometimes people feel intimidated by the police asking them to search, or they feel that if they say, "No, you can't search," then that's somehow going to be used against them, or they're going to somehow be found guilty because they didn't consent to a search. The bottom line is that you should never consent to a search of your phone, or a search of anywhere for that matter. When you consent to a search, you essentially give the police evidence on a silver platter. Now, the police that you deal with, they might be friendly with you, they might be nice, but that doesn't mean that they're not going to put you under arrest if they find evidence that they think links you to a crime. If you don't consent to a search of your phone, the police will need a search warrant in order to search your phone. This requirement applies in all states, and that's because it's a rule developed by the United States Supreme Court in the 2014 landmark case called Riley versus California. That case established a clear requirement that the police must obtain a search warrant before going through a person's phone and collecting data inside of that phone. In addition to the requirement for the police to have a warrant in order to legally search a person's phone, there's also a separate issue, and that's how the police obtain a person's phone in the first place. If the police take or seize your phone from you without proper legal justification, then that's a separate violation from the issue of the police searching the data stored inside of your phone without first having obtained a warrant. Generally speaking, if the police arrest you for a crime and you have your phone on you when you're arrested, and the police think that your phone may have evidence of a crime, in that situation, they can seize your phone lawfully as arrest evidence. This will oftentimes happen when a person's charged with, say, like a drug crime, when the police know that there are cell phone communications between the defendant and an undercover officer. In that situation, the police have reason to believe that their communications on the defendant's phone related to the drug transactions that they could use as evidence at trial. So because of that, they'll keep the defendant's phone as arrest evidence after the defendant's arrested and most likely try to obtain a search warrant in order to collect that data. However, although the police can lawfully seize a defendant's phone as arrest evidence, again, because of the U.S. Supreme Court decision, Riley versus California, the police will need to obtain a search warrant before they can lawfully search through the phone. Now, even if the police do obtain a warrant to search a phone, there's an additional issue of whether they can actually unlock a phone that's password protected or otherwise encrypted. Now, the government does have tremendous resources in an effort to unlock phones, but sometimes they're unsuccessful. Also, some companies that are focused on consumer privacy, for instance, Apple, they've resisted orders to unlock phones. So, even if the police do obtain a search warrant to search a phone, that doesn't necessarily mean that they will successfully be able to retrieve data from a phone. In addition to the data that can be obtained after going through your phone, the government may try to obtain sensitive information about your phone usage from your cell phone service provider. Historically, under what's called the third-party doctrine, courts have held that data held by third parties, such as a cell phone service provider, is not private, since the customer knowingly gives up information to the cell phone provider. such as the numbers that are called or when the calls are made. However, a recent United States Supreme Court decision called Carpenter versus the United States, that case held that cell site location data is so sensitive and private that although we know that our cell phone provider has that data, we retain a reasonable expectation of privacy in that information. Consequently, the government must obtain a warrant in order to obtain your cell site location data. So basically data that can show a general location of where that cell phone was at any given time when calls were made. The Carpenter decision, it's very possible that it may pave the way for more privacy rights with other cell phone data, such as who we call or when we make those calls. For instance, in response to the Carpenter decision, some prosecutors now seek a warrant before they obtain more generic phone records. And I think the reason for that is because they don't want the court to rule that they should have first obtained a warrant before seeking a defendant's cell phone records. Furthermore, some companies, again like Apple, they require a warrant before they turn over certain sensitive information, like iCloud data. So, although the government doesn't need a warrant to obtain a lot of data held by cell phone providers, they do need a warrant to obtain location data. And going forward, courts may require warrants for other types of data held by cell phone providers. If you've been charged with a crime and the police have searched your phone to find incriminating evidence, give me a call for a free consultation. I can assess your case to determine the best legal strategy for you.